All right, everybody, buckle up because we're diving straight into another wild day inside the courtroom. I'm breaking down every move, every reaction, and every decision the judge makes so you can see exactly how justice plays out in real time. Let's get into it.
Hey, what's up? How are you?
I'm well, Judge. How are you? I'm back on Jesse Herrera's case. Just checked with the state, and the accident report was finally shared with us yesterday.
Okay.
So I think that's what we were getting the opportunity to get the accident report, and we now have it.
Okay.
So with that said, I did already submit mitigation packet. Now I'll let them know we have accident report, so we can go ahead and move forward getting into the DWI-PTI program.
When you said it like a week to see whether they accept or deny?
Well, I had already emailed them and I got an email back, but I was waiting on the accident report before moving forward after reviewing it to make sure we're going to go that direction. So we did get accepted into it. I got the email last week, late last week as well on that one, but I was still.
You tell me, what do you want now?
I just wanted to give you an update, Judge, to let you know that we're good to go now. I have everything I need. So now I'm happy with moving forward with the DWI-PTI route.
Okay.
But I just wanted to kind of update the court because I know that's what we were.
How long do you want now?
Now that I have that, maybe if I could just do a regular setting, Judge, to make sure I get everything notarized and turned in and
Okay.
all that taken
But
care
that's the last setting. What, has he done a TRAS yet?
I'm sorry?
Has he done a TRAS yet?
Yes, TRS has already been completed. That was
Okay.
done
Got it.
months ago, Judge.
Done.
So, thank you.
Yes, ma'am. Miss Young, come on up.
Good evening, morning.
Don't look at his computer.
Sorry, I was trying to get the time from him.
How's jail?
Evening. Sorry,
How's jail? Shh.
treating us beautiful.
You know, we can't get you to come. We can't get you to appear.
Well, what happened was this time.
No, but there's always an excuse. It's really easy to just pick up a phone and call Josh. How hard is that? You know, that's all we literally ask you to do is remain in contact with your lawyer. That's all you got to do.
Yes, sir.
We've repeatedly tried 4 different times. Your lawyer's asking me to let you out to get in this program, but I know if I let you out, you're just going to
No, sir.
take off.
I'll do the program. That's not the problem, sir. Honestly, with the phone situation, that's how he has a whole different number since last time I came. I don't even have that number anymore. And with the transportation part, I don't have a car. So the way I move around is either using the bus or my feet, sir. And last time that I did come, I came on my own. No one told me to come. No one called me. I knew I ended up missing it and I came.
Unless you're wearing orange. That's the only time we see you.
No, sir, I turned myself in. I came in myself after I missed my court date and I came in by myself.
When?
I can't give you a date, but if you look on there, I sat here and waited till everybody even left.
Guys, did she turn herself in or she got arrested? Can you tell? If you turn yourself in, that would make me very happy. But if you just got arrested and that's why we have you?
No, sir, I came to court.
Young, she's on the jail dock. Last page, I think.
Looks like the booking date was the 12th, Judge, but I don't know. That's all I can see from my side.
That's when I came to 12. I've been here since.
Where did you come to?
Sorry?
Where did you go to? Did you turn yourself in the jail? Is that what you're saying?
Sir, I went to the Franklin Street, if I'm not mistaken, Franklin, 1200 Franklin, where all the court is at. Where I was supposed to go the first time. 1200 Franklin, if I'm not mistaken. Honestly, I don't even remember what day. This time? Yes, sir. I can't.
You know what we could do is we could do this, is that if we're going to do this, you know how we do that release that we release to people? Something like that. So we know that she gets to the P180 place. Where is it? Where did they do the interview? Do you know?
I guess because it's not like an inpatient facility, would it be different if it's?
Where does it happen? Do you know? Do you know where the interview happens, Josh?
I'm not sure like physically where it is, the P180. I'm checking the state though. Because I guess she wouldn't be released to that program. She'd just be released and have to.
Do you have a date already for it? Do you have a date for it?
There's like a way to book it online, but they said that you have to send a contract, a PTI, P180 contract. So, which I think is what we have now. So I think we should be able to schedule it now.
Okay, so let's do this. Schedule it, get a date, and then I'll put a GPS monitor on her prior to release. I'm not going to do this again.
Okay.
You ever take off on me again, I swear on everything that's holy, that'll be the 5th time. Do you understand? So I'm not giving you a PR bond now to just wait, get a date. We'll set it for like the day before, and then we'll give her a PR bond with a GPS prior to release. The instruction is she goes directly to get the interview done, and then we'll go from there. But I'm not going to continue to play this game.
But I'm not playing a game, sir. It's been cold. Like, what do you expect? It's been 20 degrees, sir. 20 degrees. You know how hard that is to actually stay.
Your fingers so frozen that you can't make a phone call?
Sir, I just got the phone. That's what I'm telling you.
If you need resources, we can give it to you. If you need a phone, if you need a tablet, if you need food, we have resources to give you. But you take off, you don't call, you don't come to court. So what are we supposed to think? And we just can't keep, I've got 4 different times. I can't continue to do the same thing.
We'll get the schedule.
All right. Do it and we'll see. Okay. You ready?
Yes, Judge.
Hi.
Good morning. Actually, off docket, I had a client, he was set for bond forfeiture last Friday, but he's still in custody on the felony bond that I don't think he's gonna be able to make, but he did get an interlock for the DWI, and he said he shares the vehicle, and now that he's in jail, his uncle needs to
I'm
use
with you.
it. So we can get a removal form.
So just get the removal order now. If he does get out, then he'll need to put it back on.
Right.
Okay?
Absolutely. Thank you,
Please let
Judge.
him know. Yeah. When they get older, it's,
You got Mr. Morris, Mr. Robinson.
Morris and Robinson. Good morning, guys. All right, so tell me what we're doing with these gentlemen.
We're reading extradition on both of them, Judge.
Okay. So. Mr. Morris,
Yes.
Oh, you saying Mr. Morris's?
you are wanted out of the state of Louisiana for failure to register as a sex offender. Are you waiting for an extradition?
Yes. Hey, Judge, I have a question.
Shoot.
Since the charge originated out of Harris County like 40 years ago, since I served time here since in the state of Texas, since they've been trying to make me sign up for this in Louisiana.
So what this is it looks like they filed a charge out of Louisiana, right? And they issued a warrant for one reason or the other, probably a failure to appear. It could be just a new warrant that, Dave, do you have any?
My best guess, because I don't have the underlying offense, but the originating offense that required him to register as a sex offender did come from Harris County, but they might have had some evidence that he either resided there or had an appearance in
Perhaps
Louisiana.
it got transferred over there.
Right, and so for
Or
some,
no, I mean, that wouldn't work.
But-
I don't know. I have no idea. They give us so limited information here on what the underlying case, we don't even fight the underlying case. All we do is establish who you are and whether you want to fight extradition or not. Really. And you are Sydney Robinson?
So Judge, on Mr. Robinson, we'll have the waiver on the fugitive case. And then on the assault case, if you wanted to put bond conditions, I believe state wanted no contact.
Oh, so you're on bond for an assault here out of our court here. You were also wanted out of Adams, Colorado for driving under the influence, failure to display proof of insurance, and careless driving, and
I know, Jeff. I know, but it's on there. It's one of the warrants.
low power scooter operation without a license.
Which is completely false. It was a Harley.
Don't, Billy, just,
We don't want to say.
you're waiving formal extradition on that case, right? Okay, so I don't know anything about are you representing him on the assault?
I am.
Wonderful. Alex?
Their cause number for the.
Assault?
Yes.
254-7113.
I apologize, 254-7113.
113.
Okay.
Stevie beat up.
So on the assault, the officers were dispatched to a welfare check at a residence in Harris County, Texas, in response to a disturbance. The caller, the witness, was met by the officer, and she said she kept hearing the female saying, "Stop it." The complainant stated she went to an upstairs bedroom and slept, and that the defendant entered the room, grabbed her by the throat, and lifted her off her feet. The complainant stated she did not have pain or impede breath due to the fact that she was very intoxicated and could not feel anything at all at that moment.
Did you say she was very intoxicated?
She was very intoxicated at that moment. And then on the morning of the incident, or on the 11th of January, the defendant woke up and they started verbally arguing again. And the complainant said that the defendant threw a box at her and hit her in the head. And the complainant said the defendant began to chase her in the backyard. And while she was in the corner of the backyard, the defendant ran towards her, threw her down in the mud, and began choking her with his hands. And the officer observed the complainant to have fresh bruising around the left eye and a red marking on the left and right side of the forehead.
Okay, Mr. Robinson, I'm going to find that there's probable cause to go forward on your assault case. I am ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand? Okay, so the other thing is this, Shrey, is that he's on bond for this here.
Right.
What, do we know, do we know that Colorado's coming to get him?
Yes. So they, short answer is yes. I haven't heard anything else since the original.
Okay, so we need him to sign conditions. Now, you got to be aware that if you go back, if they end up picking you back and you go to Colorado, whatever happens there, you must remain in contact with Shreya here, because if you don't, we're going to issue a warrant here. And what's happening now will exactly happen over there, where you're going to be sitting in custody over there. And then a hold is going to be placed over here. And then you're going to have to come all the way back over here. All you have to do is remain in contact with her so we know what the situation is going on. And don't have any contact with the complaining witness's case. Don't pick up any new cases. Understand?
Yes, sir.
Okay?
And Judge, in case, for whatever reason, Colorado decides not to extradite and he is released in the next week, we're gonna do a appearance required for the January 29th.
Okay. That sounds good to me.
Okay.
Okay.
Was there state conditions, Your Honor?
No, pre-trial.
Morning, Judge. We're approaching on Mrs. Troy Britton. This is the one that, oh, you weren't here yesterday, Judge. Judge Jackson was here yesterday. We were trying to do something, but I asked to bring my client here so she can know what's going on.
So Judge, the original approach yesterday, while Judge Jackson filled in, was the man jurisdiction requested an extension of 2 days, which she granted because it's 2 days and typically do that. But Ricardo wanted the accused to come to court so that it could be a more formal understanding of what's happening. And during that time for this morning is Ricardo's not telling me she is wanting to have a bond set by the court. State as opposed.
Yeah, this is the one where she's like 17 and she's got already like
she's had 7 charges,
yeah.
2 of them
She's
failure.
19, Judge.
Okay, 19, right? Yeah. Sorry, I can't. Just you scare me, man. I can't. They're all very violent cases now. You know, you're wanted as state for another. You know, sorry.
Judge, if I may,
Sure.
in talking to my client, you know, she's made valid points to me. And of course, I'm just.
I know you're advocating for your client, and I'm never going to begrudge anyone for advocating. It's your job, I know. But you're 19 years old. You've got 7 priors already. You're wanted out of another state. There are multiple aggravated assault cases. You've got 2 failure to appears. At some point, we have to say when. And now's that point. You scared me, really. I don't want anything else to happen. So,
So the extension was originally granted by Judge Jackson out to the, I want to misspeak. 24th.
I'm not doing any more. If they don't come here by that point, she gets released. Okay? All right. Thanks.
Thank you, Judge.
Thanks, Your Honor.
Bo. Hi.
Your Honor, I have a plea.
I'm ready when you are. Come up, Mr. Barreno. Was restitution paid in this case or no?
No, sir.
So it will be a part of the probation then, okay? Mr. Barreño, you are charged with driving while intoxicated. First offense. It's charged with the 0.15, right?
Yes.
Okay. Is it true or untrue that you had a breath alcohol concentration of a 0.15 or above? Okay, true to the enhancement. You have worked out an agreement where they're offering you 1 year in jail to be probated for 15 months. As part of this agreement, you will do what's called a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill any conditions that they add. 30 hours of community service, a victim impact panel. They have not put a DWI education class, though. Did you forget to put a DWI education class? And is this a true first? Is it a true first?
It's a true first, Your Honor, and it appears that, yes, we forgot to put the DWI education.
Let's do a DWI education class. 1 victim impact panel, no drugs, no alcohol, $250 in restitution to the complaining witness. You must have a guardian interlock and follow all other conditions of the court.
The guardian judge, I think we need a affidavit to go driving.
You're on probation in this court. You need to understand that if you're not in this country with permission and you go to jail and immigration finds you, they're going to put a detainer on you. So if I were you, while you're on this probation, I would live with a halo above my head. Follow all the conditions. Do not consume alcohol. Do not drive. It is a part of your probation. If you violate these conditions, I'm going to put you in jail. I will issue a warrant, put you in jail, and I'm going to bring you out. We're going to have a hearing as to whether you violated it. If you do, you are looking at an entire year in jail. Do you understand?
Yes.
You also need to understand that from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this is going to go on your record. It's going to be there for the rest of your life. You can never take it off. Is this how you understand the agreement?
Yes.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. One more caution word is that because this is going to go on your record, if you were ever pulled over, even 30 years from now, an officer sees this and they smell alcohol on you, it's probably not going to go well. Good luck, sir.
Take you to your ass already, Judge.
Okay, so whatever. Okay, good luck. You waive the fee. All right, ready?
Yes, Your Honor.
Oh, I'm sorry.
It's because we have the interpreter here. It's a Spanish plea also for Pichu.
Oh, he's pleading. He's pleading on both, huh?
Yeah, he's got to play on both. They got him in a touch.
Mr. Perechu, today is not a good day. You were on bond for DWI. You picked up another DWI. You've been able to work out agreements with both of these, but both of these charges will go on your record. They will be there for the rest of your life. You need to understand, if you ever pick up another DWI, you will be facing a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, even if you have had a sip of alcohol, I wouldn't get into a car. It is a humongous risk that you're taking. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never take these off. Do you understand?
Yes.
How do you plead to the
¿Cómo se
offense?
declara
Guilty or not
la
guilty?
ofensa culpable o no culpable? Guilty.
I will find you guilty. On one of the cases, it's alleged that you had a .15 or above. Is this true?
Yes.
Okay, true to the enhancement.
Okay, entonces,
All right, I'm going to suspend your license for a year. Do not drive. Good luck to you, sir.
That's the only thing is those.
I'm going to waive the fees.
You will.
Waive the fees? Is that what you're talking about?
Sí,
Okay,
no
thank you,
tengo
Judge.
ningunos
Appreciate it.
costos.
Yeah,
Okay.
okay.
Está bien. Buena suerte.
Approaching on Mr. Lauderdale, he's in the box.
All right. Come up, Mr. Lauderdale.
There's some cognitive issues.
I'm just asking him to be nice. You know? Mr. Lauderdale. Be nice. It's not hard. Self-control. I've given you a lawyer. You have to stay in contact with him. If he tells me that he cannot get a hold of you, I'm going to issue a warrant for your arrest. Do you understand? Okay. Do you have any questions? All right. Do you have a cell phone?
He gave me a phone number I can reach him on. His mother's.
Okay. Do you want a cell phone? We have services that we can give you so that you can get your own cell phone. Do you want one? Okay. Do you mind giving him, we're going to give you paperwork, but you have to do the work, but I'm going to give you the resources to be able to get a phone. If you need anything else, come back, talk to us, and we can try to give you whatever you need. The worst thing that can happen is that you don't come back. Okay? Perhaps we should do not waived. I don't know. It's up to you, whatever you think is appropriate. Okay? All right. Good luck.
Hey, Judge.
Josh.
Miss Young, Ashley Young.
Okay.
So the soonest P180 assessment, we scheduled it for January the 30th.
Okay.
On that one.
So let's set it for maybe the 29th. Okay, and then I'll do the PR bond, and then we'll do the GPS.
Custody until.
Yeah, I'm not. If I let her out, it's right. So I'm giving her the opportunity the day before, let you out. This is what you need to do, right?
I know you mentioned the GPS monitor, but if she doesn't have a home address, would that be an issue for the GPS monitor?
No, because I think that there's a way that we can still work it out.
Not that, okay.
I think, yeah, if you want to talk to her, but I think that there's still a way that we can work it out, even if they don't have an address. Okay? Okay, thanks. All right.
You just said the day before or the day after?
No, before. We got to let her out before.
Okay, just trying to get the order right. Okay.
Yeah. Good morning, Mr. Harris. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Is this on docket or is it off docket?
No, it's a walk-in.
May I get the cause number?
Yeah, it's 2-5. Go ahead.
And then after I say it, I need to pull it up. It's 254, counsel. 5144.
Thank you so much. On December 27th, 2024, in Harris County, Texas, officers were dispatched to a family disturbance call, and upon arrival, the officers met with the complainant's son, who stated that his parents were fighting. The officer met with the complainant, who was not cooperative, but stated that the defendant choked her, causing pain, and reported pressure of a 7 on a 1 to 10 scale. And then the officer then observed a large bruise on the complainant's arm. The complainant's son stated that the defendant had abused the complainant for a very long time, and that this is not the first time he has choked her.
Mr. Harris, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of weapons. Do you understand?
Yes, sir.
I'm entering in now what's called a magistrate's order for emergency protection. That is a court order that identifies Ms. Pisana as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat or harassing behavior, be in possession of a weapon, or go within 200 feet of the Buffalo Bend Drive address. Do you understand? If you violate this, the state can and probably will file a violation of protective order. It's one of the worst cases you can pick up. Do you understand? Okay.
Can I speak briefly?
Please.
The state has had a chance to talk to the complaining witness this morning and on January 2nd, and the complaining witness spoke with officers at the time of the investigation and said that she did not want to press charges, that they had a dispute and that it was not, as talked about by everyone else, she was not saying to anyone that she was choked or anything else. And they spoke with her this morning. She only wants a protective order against violence communications between each other. They've been married for 7 years, together for 19 years. They were together as much as yesterday, Your Honor, and that's not what she's looking for. She's looking for resolution of the case. They have a home together, they live together, raise their children together. Mr. Harris has been employed at the same company doing construction work for the last 20 years. They're fighting a foreclosure on their home. Having him move out to try to find somewhere else to live would make them keeping their home impossible.
My only concern is the violence. And my major concern is the fact that we have here children that are exposed to and see continual violent behavior. You know, when a kid sees that, what happens? You know, that's a huge concern. We have, did the child say that this happened?
Said it is not the first time.
Well, the son was not present at the incident. I think.
Well, I don't know that.
Yeah, that's the thing.
I mean, all I know is that a child telling an officer, hey, man, you know.
Son is 18, does not live in the residence, came to the residence as they were getting into it. So would not have been there, would not have saw any interaction between them. But the facts will lay themselves out, and we'll look to that, Judge, but we are asking the court would consider that.
Guys, what do you say? You heard the facts, right?
Yes.
He wants to have contact.
I just spoke with complainant and she requested no negative contact. I gave her the options of no negative or no contact altogether, and she said no negative.
So you think contact's okay?
I would defer to you, Your Honor, that's what she said, but no contact, the more restrictive is fine with us.
What scares me is that even, you know, they're going through even a more stressful time. You know, if their house is in foreclosure, it adds upon more stress. So we have these facts that are pretty bad. We've got more of a stressful situation happening now. The last thing I need or want is for anyone to end up on the news because someone does something rash that you can't recover from. You know, the thing is that when you pick up these criminal cases, right, you've dug yourself a hole. You've dug yourself a hole, but the hole is not so deep that you can't get out of. Sometimes people dig themselves such a damn big hole they never get out of. It's continually on the news every single day. 90% of the people that you see in jail, because they don't have any self-control. They get upset, they wig out and do whatever the hell they want to do without thinking, if I do this, what's going to happen? If I say this, what's going to happen? Because when stuff of this nature happens, it affects everyone. It's like a cancer. It radiates everywhere and affects everyone. And with the stressful things that are going on now, it scares me to allow contact because I don't want any further. I don't want anything worse to happen. I don't know. I don't know.
I understand, Judge. Mr. Harris has no criminal history. This is the first allegation. I know what we hear in the office report about it happening in the past. We've never had any action with law enforcement in something like this. I don't have any doubts. I've known Mr. Harris and his father for many years now, and I don't expect anything to happen, but you're right. I can't stand before the court and say that. And Mr. Harris can do everything that he can do to ensure he's used coping techniques. We've talked about him since I've been representing him about leaving the scene. It's not in the report, Judge. There's some things that we have to deal with alcoholism within the home that he's trying as a husband to work through with his wife. So there's some things that need to be done, Judge, but he's been responsible.
That's the other thing I was going to say is I don't want you consuming alcohol or illegal drugs. I'm going to test you. If I find that you're consuming alcohol or illegal drugs, you pick up a new case, I'm going to put you in jail. I'm going to tell you now, I will do everything in my power to protect my community at all costs. I don't care who is in front of me. I don't care what gender, color, or your small farm animal. I don't care. Do you understand?
Sir.
The problem is that, and what you need to understand, what is threatening or harassing doesn't matter what you think. I could care less what you think. It is what the other person perceives. So can conduct alone violate this? If I go like this, is that threatening or harassing? It most certainly is. And they can land your butt in jail in a moment's notice. Do you understand?
Sir.
How long ago did this take place?
December 27th.
27th of 2024, yeah,
So it's been a couple weeks already.
a couple weeks already.
I will allow you to have contact, but no threatening or harassing contact. And I'm telling you now, between now and the next setting, I'm going to test you for drugs and alcohol. And if I find that you're using, I will lock you up. You have to imagine that if you're in jail and the bond is set at 10 to 20,000, if you don't have anyone to pony up that kind of money, you will be stuck like Chuck until this thing's over with. Do you understand?
Sir.
Self-control. We all get upset. I have 4 kids. They drive me up that freaking wall every single day. But if I try to beat them into submission, it only makes things worse. Because hell hath no fury like a scorned woman and a teenager who's out of control. And when they see that type of what's going on, it's okay. They think it's okay. It's not.
Understand.
All right. Okay. So you will be monitored by trial. No threatening or harassing. He can go back home for now. But if I hear anything else, I'm going to unleash. You understand?
Sir.
Okay.
All right, will we be excused for him to get with pretrial on the pretrial bond?
Oh, yeah.
He's a bond set and I'm hearing no up being sent.
No what?
No more?
No, the MOAP is going to be granted.
Okay.
I'm entering in the order for protection. Everything in that order is stuff that you shouldn't do anyways. The only thing I'm taking off is the residential restriction. Everything else stays. So if you make any threats, they're going to file another case on you. And I'm going to tell you, it's the capital murder of misdemeanors. You pick up a violation of protected order. Does he have any criminal history?
No, Your Honor.
All right, I'll set bond at $100. I'll grant you a PR bond. It's the only one you're going to get though. You understand? Okay, guys. Got it. You got it. Thanks.
And that wraps up this hearing. If you're into real courtroom moments, smart legal breakdowns, and raw reactions, make sure you tap like and subscribe. I've got plenty more coming. Stay sharp, stay curious, and I'll see you in the next one.